Good day, Crime Talk aficionados. We have another great show for you today. First, Brian Walshe admits to disposing of his wife's body and misleading investigators, but he's still going to trial on the murder charge. Interesting strategy. A Chicago man charged with murder in the death of a 2-month-old infant. Wait until you hear about this. Danny Masterson points fingers at his lawyers in epic blame shift. It wasn't me. It was my defense team. An Indiana homeowner has been charged with voluntary manslaughter for shooting a housekeeper that went to the wrong house. How the tables have turned, and apparently the pants have turned. The DoorDash driver's viral victim story, well, ends her up in handcuffs. An Alaska man sentenced to 70 years in an orchestrated catfishing scheme. We've got some headlines that we couldn't get to. This day in legal history, our quote of the day, and our dumb criminal. Let's talk about it.
Lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below and hit that little bell for notifications so you get notice of when we go live or put up new content. And yes, you can check us out on any of your favorite podcasting apps. Before we get started, let me quickly remind you to go to crimetalksearch.com. You want to check somebody out, get the tools you need to go do it, crimetalksearch.com. Also, go down below, hit the merch, get yourself the Christmas gear that you want. We all know your spouse is going to fail miserably in getting you the Christmas gift you want, which is Crime Talk merch, right? And so what you need to do is take action, right? What do we talk about here? It's all about taking action. Go hit the link below. Order what you want, okay? Order what you want. Make sure it gets there in time. You order today. It'll be there in a couple of days. And you'll have Christmas taken care of. Order one for your spouse. Order one for you. And everybody's happy. Do it. Christmas will be here before you know it. Don't hesitate. All right, so let's go and get to the docket. Let's open the record for Tuesday, November 18th, 2025. All right, Brian Walshe on charge for murder and, accused of disposing of his wife's remains and lying to the police investigators. Well, he pled guilty to 2 out of 3. And now they're seating a jury for the murder case. Interesting strategy. So, in a significant development in the high-profile Massachusetts homicide case, Brian Walshe entered guilty pleas to 2 lesser charges connected to the disappearance and presumed death of his wife, Anna Walshe, while steadfastly denying involvement in her murder. The partial plea agreement was accepted by the judge, Diane Frenier, as jury selection began for the remaining first-degree murder charge. Now, Walshe is a 49-year-old resident there in Massachusetts, and he's accused of killing his 39-year-old wife, a real estate executive, on or about January 1st of 2023. Then he's accused of dismembering her body and discarding the remains in multiple dumpsters. Now, Anna Walshe, a mother of 3 young children, was last seen alive shortly after midnight on New Year's Day, 2023. Her body has never been recovered, complicating the prosecution's case, which relies heavily on circumstantial evidence, including incriminating internet searches allegedly conducted by the defendant. For example, Googling on his son's iPad how to dispose of a body. Anyway, during today's hearing, Walshe changed his pleas from not guilty to guilty on charges of improper conveyance or removal of a human body and misleading a police investigation. Now, prosecutors contended that Walsh's deliberate obstruction through false statements and delayed reporting allowed dumpster contents containing his wife's remains to be collected and incinerated before authorities could actually intervene. So in open court, the judge directly questioned Walshe about the disposal charge. Did you, in fact, willfully remove or convey the body of Anna Walshe or her remains, not being lawfully authorized to do so? Walshe responded affirmatively. His defense attorneys clarified that the admission applied solely to impending the investigation and explicitly excluded any acknowledgement of homicide. Obviously, a strategic decision, right? So, Walsh's approach, as calculated rather than unconventional, that's for sure. By conceding the disposal and the obstruction counts, the defense achieves several objectives. First, it removes potentially inflammatory evidence from the jury's consideration, such as graphic details of dismemberment and the defendant's alleged purchase of the cleaning supplies, tarps, and a hacksaw. Now, it narrows the trial's focus exclusively to whether Walshe's actually caused his wife's death, avoiding a scenario where jurors might convict on murder based partly on the revulsion over the post-mortem treatment of the body. It's a signal to the jury that Walshe accepts responsibility for certain actions while forcefully contesting the core accusations, potentially portraying him as forthcoming rather than wholly evasive. Now, prosecutors reportedly refused any plea deal that did not include the murder charge, leaving Walshe no option for a comprehensive resolution short of trial. Now, sentencing on the 2 guilty counts will occur after the murder verdict, meaning Walshe faces the possibility of additional penalties if convicted, obviously, of the homicide. Now, this is a kind of a strategy decision. The defense is going to say, Judge, we've pled guilty to these charges, and you shouldn't allow in all this evidence of, kind of the consciousness of guilt, disposal of the body. I think some of it, if not all of it, will come through, but the focus now is murder, right? Was it an accident? Was it heat of passion? Something along those lines. And then I panicked, and then I did things I shouldn't have done. I would anticipate something like that. Kind of an interesting strategy from a crazy guy. Remember, he was just, his attorney says he wasn't competent to proceed. But fortunately, they got him all fixed up at the state hospital, and we're ready to go. So anyway, since those matters are resolved, the jury selection commenced immediately following the plea, with the court aiming to seat 12 jurors and 4 alternates before Thanksgiving. Now, the prospective jurors are being instructed to abstain from all news media and social media during the proceedings, a requirement the judge acknowledges quite demanding. And as we talked about yesterday, we have jurors that were dishonest. Let's hope the jurors are honest in this particular case so that each side gets a fair trial. But if you have jurors on there for some particular purpose other than doing their job as a juror, it's not a fair proceeding, and it frankly isn't fair. And I frankly am of the mindset that if jurors are not going to be candid and forthright, well, they should be prosecuted if it comes out and you determine that they lied, like the juror we talked about yesterday in the Karen Reed case, who basically said, I had no interest in doing anything other than finding her not guilty. He lied. Why should he not be prosecuted, in my humble opinion? Do I think it'll happen? No, but it should. Anyway, we digress. So in pretrial motions decided on Monday, the judge permitted testimony regarding a heated argument between the couples days before Anna Walshe's disappearance, during which she allegedly pressed Walshe to resolve pending federal art fraud charges. Now, evidence of Walshe's internet searches, including queries about disposing of a body and pornography involving infidelity, was also deemed largely admissible, though certain explicit details were excluded to prevent undue prejudice. That's a 403 analysis under the rules of evidence. Anyway, the defense has argued that some of the searches reflect personal fantasies or adult interests rather than criminal intent, while prosecutors maintain that they demonstrate premeditation and motive tied to the suspicion of marital infidelity. Notably, several Massachusetts State Police personnel involved in the controversial Karen Reed case, including the embattled former trooper Michael Proctor, appear on the witness list, potentially inviting scrutiny of investigative practices. Now, a recent psychiatric evaluation confirmed that Mr. Walshe was in fact competent to proceed and stand trial, and his request for a change of venue due to pretrial publicity was denied. As the proceedings move forward, the case underscores the challenges of prosecuting murder without a body or direct witnesses, placing extraordinary weight on digital forensics, timeline discrepancies, and the defendant's own admissions regarding the aftermath of Anna Walshe's disappearance. Now, I think that this is going to help the prosecution because if he testifies, he can certainly be cross-examined on the fact that he pled guilty. And so we know that she was dead and that we would have a body unless, of course, he had not gotten rid of it. So we'll see where this goes. It's going to be interesting. I really think it's going to be worth something worth watching, and I believe we're going to bring it to you once we have a jury selected. Next, a Chicago man charged with murder in the death of a 2-month-old infant. This is absolutely outrageous. So on November 12th, the Chicago Police Department announced the arrest of 23-year-old Anthony Evans in connection with the death of a 2-month-old boy. Now, Evans faces 1 felony count of first-degree murder with a strong probability of death or great bodily harm. Now, the infant, identified by family members and multiple news sources as Kayson Flowers, was pronounced dead on April 28th of this year after being found unresponsive. Now, according to the Cook County Medical Examiner's Office, the cause of death was multiple injuries consistent with child abuse. The manner of death was ruled a homicide, which simply means it was not an accident, wasn't suicide, wasn't undetermined, but it was a death caused by another person. That's the official definition of homicide for medical examiners. So police reports indicate that on April 28th, the child's mother, Kayla Flowers, retrieved the infant from Evans, who had been caring for the boy. Now, Evans allegedly returned the child in a stroller, stating that the infant was asleep. Upon arriving home and removing the cover from the stroller, Flowers discovered the child was unresponsive and lifeless. Medical personnel later informed the family that the infant had likely been deceased for 6 or 8 hours prior to being returned. Evans was taken into custody nearly 5 months after the incident, and a post on a Facebook titled Justice for Kayson stated that the family had been notified of the arrest. Obviously, no trial dates have yet been announced. Obviously, he's entitled to the presumption of innocence, but a 2-month-old, really? My goodness, ladies and gentlemen. 2 months old. Why didn't somebody pick on somebody their own size? Really? Come on. Next, Danny Masterson points fingers at his lawyers. It wasn't me. It was my defense team that screwed this whole thing up, right? Because the defense attorneys created all the facts that just happened to get Mr. Masterson charged and convicted by a jury of his peers, right? I hate post-conviction relief, but let's talk about what's going on with Mr. Masterson. So in the latest installment of Celebrities Behaving Predictably, disgraced That's 70 Show actor Danny Masterson has officially entered the post-conviction blame game, filing a whopping 183-page habeas corpus petition that essentially reads, "My lawyers did it, not me." Yes, the same Danny Masterson currently enjoying a 30 years to life spa retreat at the California's men colony for drugging and raping 2 women back in 2003. Alleged allegations he still insists were just really enthusiastic consensual encounters. Now claims his freedom was stolen not by his actions, but by the incompetence of his former legal dream team, Philip Cohen and Sean Hawley, because nothing says innocent man like throwing your highly paid attorneys under the prison bus the moment the gavel falls. Masterson's new knight in shining armor, attorney Eric Muthaup, solemnly declares that the jury only heard half the story, the prosecution side. Translation: if they just let Danny present his side, complete with 65 exhibits of allegedly exculpatory evidence that somehow never made it to trial, the outcome might have been different. Or as the attorney put it, with a straight face, Danny deserves a new trial where the jury can hear his side as well. Among the petition's greatest hits, Cohen allegedly failed to call friends of the victims who were ready to testify the encounters were consensual, friends who conveniently were never called. He didn't mount a proper affirmative defense of consent despite the original trial featuring repeated arguments that no drugs were proven. And in a twist no one saw coming, he neglected to parade enough Scientology witnesses to counter claims that the church discouraged reporting. Because when you're accused of using your religion, alleged policies of silencing victims, the solution is obvious: more church members on the stand. Anyway, the filing also recycles arguments from Masterson's previous appeal, proving that if first you don't succeed in overturning a conviction, just try again with slightly different wording and twice the page count. Meanwhile, estranged wife Bijou Phillips has moved on so thoroughly she's even petitioning to drop Masterson from their daughter's name faster than Danny dropped responsibility for his own trial strategy. Moral of the story, folks: in Hollywood, accountability is like forensic evidence of drugging, apparently optional. Like I said, I get it, ladies and gentlemen. Nobody wants to go to prison. Clearly. And there are people that have been wrongfully convicted. Masterson, in this particular case, was convicted by a jury of his peers. First trial, hung jury. Masterson had very competent attorneys. I guarantee you nothing was done without Masterson's approval as it relates to trial strategy, whether he testified or not to testify, basically presenting no evidence or not presenting everything. But when you are behind bars, you want to get out of prison. Now, when you do your appeal after you lose at the trial court level, you make an appeal saying that the court erred, made a legal mistake that resulted in an unfair trial, and it's solely based on the evidence presented, what is in the record and nothing more. You don't get to bring in extrinsic evidence or things that we thought we were going to do. You lose those appeals, then you're done. Then you have to do what's referred to as post-conviction relief, normally in the state proceedings. Then you file in federal courts under habeas proceedings. But you have to exhaust those remedies first before you get to federal habeas petitions. But basically it's saying my attorneys were ineffective. Like I said, just because you lost doesn't mean that your attorney was ineffective. Effective assistance of counsel is a pretty low bar, all right? You basically, there are cases where people were falling asleep during death penalty cases, and the United States Supreme Court said he was effective, all right? You have to work pretty hard to be found ineffective. It could happen. I've seen some attorneys fall on their sword because they felt really bad for the client, and they said, yeah, I must have messed up. But the problem when you do that, guess what? Then prosecutors will say, ooh, well, if you're saying you're ineffective, my goodness, you probably shouldn't have a license to practice law. Let's go grieve you with your state bar. So it's really a double-edged sword. And of course, now the attorneys are on the defensive, like, no, we did everything we could. I can't believe this guy's doing this to me. And guess what? When you file post-conviction reliefs, guess what? It's a waiver of the attorney-client privilege. So now, all those detailed notes that the attorneys took during their conversations, admissions maybe that they were aware about, why, say, for example, why the defendant couldn't testify, well, they all get turned over to the new post-conviction attorneys and, oh yeah, the prosecution as well. And so the prosecution will now work with his old attorneys to a limited extent to make sure that he doesn't get a new trial. I hate post-conviction relief. I get it. But you have to remember, at a certain point, and if an attorney screwed up, if they were on drugs or drunk and they showed up for court, clearly ineffective. Completely, ignored an eyewitness that was right there at the scene and didn't talk to them, or at least attempt to talk with them. Okay, possibly, maybe malpractice. It would depend. But just because you lost is not a basis for it. I hate post-conviction relief with a passion. And it frankly takes out all the fun of practicing law these days, because what do? You have to paper your file for the post-conviction claim that will come if you lose. Even if the attorney has done everything right, client thinks that he is the greatest thing since sliced bread. I've literally had clients tell me, Scott, man, you did a great job. You're my boy. You did great. I need you to do my post-conviction. I'm like, dude, I can't. I didn't do anything wrong. We just had some really bad facts. And client's like, no, you're my guy. I need you to do my post-conviction. I'm like, dude, you can't, because you're saying that I was ineffective. He goes, but you weren't ineffective. You were great. And I'm like, I know. That's what I'm trying to tell you. And so it's just part of the process. You get used to it. Heck, I've won cases where, I swear to God, won a homicide trial. Client got the final bill and said, I think you spent a little too much time preparing. Thought my bill was excessive. On a homicide, going to spend the rest of your life in prison. Well, let's just say he paid the bill. Next on the docket, an Indiana homeowner charged with voluntary manslaughter for shooting a housekeeper at the wrong address. A 62-year-old homeowner in central Indiana has been charged with voluntary manslaughter following a fatal shooting of a 32-year-old mother of four who mistakenly arrived at his residence while en route to a scheduled cleaning assignment. Kurt Anderson was taken into custody and formally charged in connection with the death of Maria Florinda Rio Perez, according to the Boone County prosecutor, Kent Eastwood. Now, the decision to pursue charges came after an extensive review of the evidence and applicable state laws, during which police determined that Anderson's use of deadly force did not qualify for protection under Indiana's Stand Your Ground statute. They said, quote, after examining all available information, relevant statute, and judicial precedent, the appropriate course of action became evident, the prosecutor stated during a press conference. The incident occurred on the morning of November 5th in the Indianapolis suburb of Whitestown, and Rios Perez and her husband, Mauricio Velasquez, had been contracted through their housekeeping service to clean a newly constructed model home in the area. Believing that they had located the correct property, the couple consulted a mapping application multiple times and drove around the neighborhood to confirm the address before approaching the front door. Now, according to the police reports, Rios Perez attempted to unlock the door using keys provided by their employer. Within approximately 30 to 60 seconds, a single gunshot was fired from inside the residence, passing through the closed door and striking her in the head. Now, that's going to be key, ladies and gentlemen. She was pronounced dead at the scene from the gunshot wound. Now, responding officers found Velasquez cradling his wife amid a significant amount of blood on the porch. The front door remained closed throughout the encounter, and investigators confirmed the round originated from within the home. Court records indicate that Anderson informed police he had been awakened by noises at the door after limited sleep the previous night. Perceiving an attempted forced entry, he retrieved a handgun from a room he described as a safe room, positioned himself at the top of the interior staircase, and discharged the weapon after the sounds appeared to intensify. Following the shot, he instructed his wife to contact the police and reported to the dispatcher that an individual were attempting to break in. Anderson and his wife remained inside until law enforcement secured the scene, at which point they exited and were briefly detained and questioned. Now, Velasquez, who was working alongside his wife for the first time that day, expressed profound grief in interviews with the local media and says justice is needed because a life was taken without justification, he said, adding that he now serves as the sole parent to their 4 children, ranging in age from 11 months to 17 years. Well, Anderson's defense attorney, a guy by the name of Guy Relford, described the event as a tragic misfortune while asserting that his client's response was legally permissible. Although the loss of Mr. Rios Perez Velasquez is heartbreaking for all the involved, we are prepared to demonstrate in court that Mr. Anderson's actions were entirely justified under Indiana's Castle Doctrine, which permits the use of reasonable force, including deadly force, to prevent an unlawful entry into a dwelling. Now, Anderson is currently detained without bond pending an initial court appearance. The case has prompted renewed discussion regarding self-defense laws and the circumstances under which homeowners may lawfully employ lethal force against perceived threats. Now, ladies and gentlemen, here's the big issue. Now, not that I'm telling you to shoot people if they're coming into your house. You got to consult your own state law as it is. But generally, most of the castle doctrines or make your day kind of thing, they got to pass the threshold of the door. Okay. When the door's not open, it could just be, that somebody trying to get in mistakenly there, but they didn't break the plane of the door. Now, do I think that this homeowner will be found guilty? I don't know. It'll be a question of fact for the jury to decide whether he acted reasonably or was he acting recklessly. The bottom line is, well, it doesn't really matter what everybody believes, but the prosecutor has charged the case at this point. All right. Now, if I was the prosecutor, I would say, by God, if they had crossed the plane of that, door, it had opened up. At that point, you didn't know who it was. You were in fear of your serious bodily injury or death. Fire away. Right. But since they never broke that plane, something to think about, ladies and gentlemen. Now, you may be saying to yourself at home, hey, I wouldn't wait till they got in the door. I'd do the same thing. Well, you can try, but there's going to be a hole in the door. And even if you try to drag them off the porch and into the house, they're going to know that things just didn't line up. So don't do it. All right. Little practical pointer there, ladies and gentlemen. Across the plane. Next, how the tables and pants have turned. The DoorDash's driver's viral victim story, winds her up in handcuffs. In a twist that could script its own episode of a courtroom drama, complete With more reversals than a bad plot device, a 23-year-old DoorDash driver in Oswego, New York, has discovered that playing judge, jury, and viral executioner on social media can come with, well, felony-sized consequences. Please meet Olivia Henderson. She thought that she had stumbled upon the ultimate gotcha moment on October 12th, arriving at a customer's home to find the front door ajar and the resident sprawled on his couch, blissfully unconscious from what police later described as a generous helping of alcohol, with his lower half decidedly underdressed for company. Rather than quietly leaving the order and moving on with her night, Henderson whipped out her phone, captured the compromising scene from the doorway, and promptly broadcast it to TikTok, framing the intoxicated sleeper as a deliberate exposer who had sexually assaulted her simply by existing in that state. The internet predictably erupted. Henderson leaned into the victim narrative across multiple videos, tearfully decrying her deactivation from DoorDash, accusing the app of punishing her for exposing my assaulter, and claiming TikTok was silencing her story by removing the click and issuing strikes. She even lamented the loss of her gig, insisting, "I'm the victim here," a refrain that echoed loudly until, well, police actually investigated what happened. Turns out the only assault on display was against the privacy laws. Oswego police found zero evidence that Henderson had been touched, lured, or otherwise victimized. The man passed out cold, obviously to the world, let alone any delivery drama. Footage confirmed Henderson filmed from outside, no entry required, and then splashed a vulnerable person's humiliation across the web for likes and sympathy. DoorDash, far from villainous, clarified they ban no one for reporting safety issues, but draw a hard line on doxing customers in their own homes. Both parties lost their accounts, his for the unfortunate wardrobe malfunction, hers for turning a private mishap into a public spectacle. Fast forward to November 10th, Henderson, the self-proclaimed victim, was arrested and slapped with 2 serious charges: unlawful surveillance in the 2nd degree and disseminating of unlawful surveillance images. She was released with a court date of December 4th, while the actual vulnerable party cooperated fully with the investigators. Moral of this cautionary tale: in the age of instant virality, pausing to consider consent, context, and consequences might have, saved more than just your reputation. As one police caption widely noted, think twice before hitting post, because karma, much like a Ring camera, is always recording. The tides and deeds have a wicked sense of humor when the full truth washes ashore. Next, an Alaska man gets 70 years for a catfishing scheme. November 15th, Caden McIntosh, 22, was sentenced to 85 years in prison, with 15 years suspended, resulting in a mere 70 years to serve for his participation in the 2019 murder of a 19-year-old Cynthia Hoffman. Now, McIntosh pled guilty to second-degree murder as part of a plea agreement that allowed a sentencing range of 30 to 85 years. The crime occurred back on June 2nd, 2019, when Hoffman was taken to a hiking trail at the Thunderbirds Falls, which is apparently north of Anchorage. She was bound with duct tape, shot once in the head by McIntosh, and her body was disposed of in a nearby river. The Anchorage Superior Court Judge, Andrew Peterson, described the act as a premeditated murder, noting that McIntosh actively participated in the planning, the killing, and selecting of the victim, despite not being the primary organizer. Now, McIntosh was the final defendant among 6 individuals charged in this case to be sentenced in adult court. Now, the murder was orchestrated by Darren Schillmiller, then 21, of Indiana, who posed online as a wealthy individual named Tyler. Schillmiller contacted Danelle Bremer, then 18 and acquainted with Hoffman, offering $9 million in exchange for the kidnapping and murder of a female victim, along with photographic and video evidence. In reality, Schillmiller was unemployed and residing in his grandparents' basement. Bremer recruited McIntosh and others to carry out the plan. Schillmiller has pleaded guilty to solicitation to commit first-degree murder and a federal charge of conspiracy to produce child He was sentenced to 99 years with parole eligibility after 45. Now, Bremer pled guilty to first-degree murder and received a sentence of 99 years without suspension back in February of 2024. Caleb Leland pled guilty to second-degree murder on November 10th of 2024 and was sentenced to 40 years with 10 years suspended for providing the vehicle to use to transport Hoffman to the site. 2 additional defendants were adjudicated in juvenile courts, and prosecutors characterized the incident as a premeditated contract killing motivated by the promise of financial reward from Shill Miller, which never existed. Next on the docket, headlines we just couldn't get to. Husband stabs wife to death with scissors over suspected cheating. In a brutal domestic attack in Texas, Cassandra Judson pleaded, "Baby, I love you. Please stop. I'm dying," as her husband stabbed her repeatedly, standing over her without help. He believes that she was unfaithful. Man executes couple, leaves a toddler with parents' bodies. A suspect allegedly shot a couple dead in their home, leaving their blood-covered 2-year-old child alone for 12 hours, where the toddler tried to cuddle and play with their lifeless bodies in the horrifying scene. Pregnant woman prostituted by husband in a love triangle. A bizarre case involving a millionaire's fatal love triangle where a pregnant woman was prostituted by her husband, led to some violence. A man breaks into ex's home, stabs her mother. A brutal home invasion where a man stabbed his ex-girlfriend to death in her sleep and injured her mother, turning a family home into a bloodbath at 7 a.m. Couple murdered at home after a chilling 911 call. William and Janina Hayes were shot dead in their waterfront home by a friend over money. The wife was heard pleading on a 911 call before the gunshots. A businesswoman's body was hidden after her husband discovers an affair. That's right, a woman's body was wrapped in a rug found near her mother-in-law's home after her husband uncovered her affair in a calculated murder. Maybe we'll get to those tomorrow. Next on the docket, this day in legal history, November 18th, 1978, the Jonestown Massacre and the murder of Representative Leo Ryan. That's right, over 900 members of the People's Temple die in Jonestown, Guyana, in a mass murder-suicide orchestrated by Jim Jones, shortly after U.S. Congressman Leo J. Ryan is assassinated at a nearby airstrip. Ryan became the first sitting member of Congress killed in the line of duty, spurring congressional inquiries and legal debate over cults, mental coercion, and federal protection of officials abroad. November 18th, 1996, Ohio v. Robinette. The United States Supreme Court rules in that case in 1996 that the Fourth Amendment doesn't require police to tell a motorist they are free to go before requesting consent to search a vehicle, significantly shaping everyday traffic stop and consent searches. You ever notice on all those viral videos you see, ladies and gentlemen, the matter's resolved, here's your ticket. Would you mind if I search your car? And usually people say, sure, why not? Yeah. Cops don't have to tell you that you're free to go and that you can refuse. That's why you have to come to CrimeTalk and know your rights. I don't care if you're dirty or you got nothing in the car. When they ask, may we search your car? You say no. Now, there, of course, are some exceptions, like at the border, where you don't have that expectation of privacy, but you get the gist. Next on the docket, our legal quote of the day. Injustice anywhere is a threat to justice everywhere, and we are caught in an inescapable network of mutuality, tied in a single garment of destiny. Whatever affects one directly affects all indirectly. Martin Luther King wrote that in his letter from the Birmingham jail in 1963. And then finally, our dumb criminal of the day. Take a look at this guy, arrested after his multiple failed attempts to escape on a dirt bike in Miami. My first question is, why are you riding a dirt bike down the streets of Miami? That's what I really want to know. Anyway, he's just dumb. All right, ladies and gentlemen, that's all we have for you today. Thanks for watching. We'll see you next time. And I'm going to go to the other side of the state. Maybe we'll see you from there tomorrow. Have a wonderful day. And remember, the Constitution matters.